Thank you very much, Joyce. Our next speaker is Dr. Stephen P. Halbrook. Dr. Halbrook is a research fellow at the Independent Institute. He also filed an amici curiae brief on behalf of 55 members of the Senate President, and 250 members of the House of Representatives before the Supreme Court in the Heller case. He received his JD from Georgetown University Law School and PhD in social philosophy from Florida State University. He's taught political philosophy at George Mason University, Howard University, and Tuskegee Institute. He's the winner of 3 cases before the Supreme Court dealing with gun issues, but none on the Second Amendment has come up until, of course, the current one. He's also testified before numerous Senate and House committees. In addition to his book, The Founder's Second Amendment, which I mentioned, his many books include That Every Man Be Armed, Evolution of a Constitutional Right, A Right to Bear Arms, the Firearms Law Textbook, Freedmen, the 14th Amendment and the Right to Bear Arms, 1866 to 1876, State and Federal Bills of Rights and Constitutional Guarantees, and Target Switzerland, Swiss Armed Neutrality in World War II. His scholarly articles have appeared in many journals. His popular articles have appeared in publications like the Wall Street Journal, USA Today, and elsewhere. He's appeared on many talk shows. Very pleased to introduce Steve Halbrook.
Thank you, David. It's a real pleasure to be here. Having just published the new book, The Founder's Second Amendment, I have a few acknowledgments I'd like to make. First of all, to you, David, for helping to push this book through and to promote it to get a really nice publisher, I&D Publishers out of Chicago. It was considered by a number of presses. We had a lot of vetting of the book. We had a lot of readers, some of whom I know who they are, others are anonymous. And one of those I'd like to acknowledge is Professor Joyce Malcolm, who I think I've never told you this, but I got better comments from you, Joyce, than from any other person who made comments. The comments range when you do a project like this from the good, the bad, to the ugly. And especially on a topic of this type, you really get varied comments. I'd also like to thank my long-suffering wife, Brenda, and my daughter, Melissa, for their patience in enduring me writing yet another book, which takes a lot of my time. And at any rate, the book is out. I hope you'll enjoy it. I want to say a few words about what's in the book, and then I'd like to talk about the case before the Supreme Court and to discuss a major aspect of what each of the 9 justices had to say at the oral argument in March. A little knowledge is a dangerous thing, and I think that was exhibited in that argument. So if I can bridge the gap between the history and what's going on today, then I would have succeeded in what I'm trying to do tonight. The first part of the book is, I think, the most exciting part. It's having to do with the pre-revolutionary colonial period when the British were tightening the screws and the patriots were resisting, and you see a spiraling of things getting out of hand. And our subject, the right to keep and bear arms, really starts in September of 1768. And at that point, the colonists had basically made clear they would not pay the various taxes that were being imposed upon them without representation. And the British were British troops were sailing to Boston to occupy Boston. And at that time, radical newspapers like the Boston Gazette had anonymous writers like Samuel Adams, John Hancock, and others. And one of the papers in early September of 1768 said that the British are coming, and it is said they're going to be doing things that are worse than anything we've endured ever before. And the very first of the 3 things they listed was that they would disarm the inhabitants. They would also take people away who were patriotic and send them to England for trials without juries. And the Royalists denied that would take place, but that was the first time a standing army occupied any American city. And it led to conflicts with the population. And if we start going through the years, we have the Boston Tea Party, and that was just one more stage in this escalation. One thing I did a lot of in the book was to find old diaries and letters that were written that have remained obscure since the 1700s. And one of the diaries I found said that in Boston, right before the Tea Party, you couldn't buy any pistols because they were all bought up. And so it was basically a situation of the colonists were arming themselves, the British were trying to prevent them from arming. And finally you have the Boston Massacre and the complete escalation of bad relations. But it showed you could get a fair trial in America because you had John Adams defending the British soldiers and at the same time defending the right to keep and bear arms, and actually getting the soldiers acquitted of most charges for shooting persons. And you had prosecuting for the crown were other patriots. So it was kind of a strange mix. But as the years go on, by 1774, things were getting pretty desperate. And at that point, General Gage, who was the British commander and also the governor of Massachusetts, was trying to turn the screws and to disarm the colonists in every way possible. There was debate in what we could call the city council in Boston about disarming the people there. These were councilors that were imposed by the colonists, by the British monarchy. They were called the mandamus councilors, and they were persons who were not elected by the locals. And basically they said that it would be ideal to disarm the people, but they couldn't do it. So there were other ways to do it, though. For one thing, George III imposed a ban on the exportation of arms and ammunition into the colonies, and by the same token, a ban on the importation into the colonies of those things. So you had the usual cat and mouse smuggling game going on, of which John Hancock was most famous. And you also had, as for the gunpowder supplies that were in the colonies, at that time, because of the volatile nature of black powder, you had large quantities being stored in what they called powder magazines or powder rooms, and there would be a keeper of it. And General Gage would prevent the keepers of the magazines from letting merchants who dealt in things like powder, gunpowder, to obtain any supplies. So it was a way of trying to disarm the colonists by not letting them get ammunition. As events escalated, you had the organization of many colonists into armed associations, and their drilling and forming themselves spontaneously into militias. You had, for example, the Fairfax County Independent Militia Company that was organized and armed by George Mason and George Washington. These were not the royal militias that were the official militias of the established government. You also had, and this took place more in Boston than any other place, that was a hotbed of radicalism and the strongest, what we could call Second Amendment values of that day. It's quite different today. You began to have quantities of arms and ammunition being taken in and out of Boston, and so at that time Boston had what was called the Neck, which was a kind of a narrow area. It's now been filled in with and made into land, but at that time the British could set up sentries at what was called the Neck, and they could stop everybody going in and going out. And the colonists were, in newspaper articles, would say things like, well, the British would stop a wagon and they would find, they were searching for bullets, but they would find printing presses. So they were the angels. And the British would say, oh, well, the colonists were taking wagons of what was supposed to be manure through there, but for fertilizer, but underneath would be arms and ammunition. So you had a game being played, and finally you had the British searching persons who were to see if they were carrying arms and then seizing them. One gentleman had the gall to go see General Gage and to say that I've been taking ammunition through there on many occasions, and I'm a merchant, and I want my ammunition back that your men have seized. And Gage told him to go file a lawsuit, and of course it went nowhere. He never saw it again. And then entrapment was going on. You had colonists trying to buy guns from British soldiers, allegedly. The colonists would deny this. but then you also had British soldiers trying to set up colonists and to say, hey kid, want to buy a gun? There was one fellow who, there were affidavits filed with different versions, but he claimed that they tried to make him buy a gun, and he finally was prevailed upon to buy it, and then the soldiers ended up tarring and feathering this gentleman. And that led to a lot of conflict that would happen. Finally, as things escalated out of control, you have the conflict at Lexington and Concord, the shot heard around the world, and the big story that nobody's ever heard much about is that after that took place, when the British retreated to Boston, General Gage basically was holding the people of Boston hostage. Things were scarce, it was hard to get food, they were subject to oppression by British soldiers, so everybody wanted to leave Boston. And Gage said that if you will only turn over your guns to the selectmen of Boston, your elected representatives, for your safekeeping, then you can get a pass to leave town. So they took all their guns by agreement to Faneuil Hall. Some of you have been there as tourists maybe. It still stands today. It's a beautiful building. That's where they had their public assemblies. And the selectmen carefully took their names and recorded the type of gun and all that for safekeeping. And then at the end of the day, here come the lobster backs and surround the building and seize all the guns. And that led to quite a reaction in the colonies, because by that summer of 1775, the Continental Congress passed a declaration of causes of taking up arms and cited the seizure of arms in Boston as one of the causes of basically turning to this Revolutionary War. And by the way, once the people had turned their guns in, then Gage wouldn't issue them the passes to leave. And so that was considered adding insult to injury. And after that point, things got out of hand, and then we're fighting a war, so there's less talk about rights and violations of rights, and more, if you look at the newspapers of the day, for example, articles about battles and conflicts and all of that. But by 1776, right when the Declaration of Independence is being formulated, the states independently on their own began to have their own conventions and to form state constitutions, and some of them formed bills of rights. And there were a couple of states that passed Bill of Rights guarantees as to the right to bear arms of the people, right of the people to bear arms for defense of themselves and the state. There were a couple of other states which had had specific limited objectives in their declaration of the right to bear arms, and I'll say more about that in a minute. So then we go through a period of constitution building at the state level, and finally we reach the end of the Revolutionary War, and we have the Constitutional Convention in Philadelphia proposing a constitution, a federal constitution, which immediately led to outrage by what became known as the Anti-Federalists because it had no Bill of Rights. We enter into three phases of the ratification dispute on the Constitution. The first phase, the adherents of a Bill of Rights could get nowhere. There were Federalist majorities in each convention getting the Constitution ramrodded through with no call for amendments. But in the Massachusetts Constitutional Convention, Samuel Adams proposed a Bill of Rights about free speech and the right of peaceable citizens to keep their own arms. In Pennsylvania, the Constitution passed without any recommendations for amendments, but the so-called dissent of minority wanted to guarantee a Bill of Rights, including the right to bear arms for self-defense, for hunting, for defense of the state, and for national defense. Finally, at the end of that period, New Hampshire was the first state to successfully adopt the Constitution and ask for a Bill of Rights, including a guarantee of the personal right to keep and bear arms. The next phase of that debate, the proponents of a Bill of Rights got the upper hand, and that was the Virginia Constitutional Convention in 1788. If you go back and read those debates, everything the Anti-Federalists predicted about what would happen with the Constitution not only came true, but was worse than they could ever have imagined. But they did stick with it. They did succeed in reaching a compromise with the Federalists in having adopting the Constitution, but then proposing a Bill of Rights, a Declaration of Rights, and with the commitment by James Madison in particular that when the first Federal Congress would meet, that a Bill of Rights would be put on the agenda. And that was a watershed moment when that compromise was reached. So then we come to the third phase of the adoption of the ratification of the Constitution, and at that point we have North Carolina and Rhode Island and some other states basically saying that we're not going to even adopt the Constitution until a Bill of Rights gets proposed. That leads us to June the 8th of 1789 when James Madison stood up in the first House of Representatives and proposed a Declaration of Rights, including what became the Second Amendment. We have published commentary about the meaning of it by Tench Coxe, a famous Federalist, who said that to prevent tyranny and so that a standing army doesn't oppress the people, that the people would be guaranteed the right to keep and bear their private arms. And then we go through a period in which the Bill of Rights gets proposed by the Congress and then adopted by the states. And finally, by 1791, that had taken place. And in that same year, Congress debated a Militia Act, and you have the enactment of the Militia Act of 1792, in which every able-bodied white male citizen was required to provide his own arms and to enroll in a militia. That's getting toward the end of the book, but we take it through the period in which the founders passed away, basically. And it turns out that I have some personal things about the founders in that chapter. They were big gun collectors. Thomas Jefferson goes to Paris and to London, and he goes on shopping sprees for fine guns, fine wines, and fine books. And he basically was a collector of those things and brought them back. All of the founders had guns. It's rather disingenuous, some of the amicus briefs that were filed in this Heller case in the D.C. matter argued that the founders were afraid of guns and they were afraid of the people having guns, and they basically have created a fantasy world that was completely adverse to life in those days. The conclusion of the book is, what does the Second Amendment say? And there I do a linguistic analysis of each phrase in the Second Amendment. And I'd like to bridge that point, summarizing what the book is about, to the Supreme Court argument, because that's where the first question was asked in the Supreme Court argument: what does the Second Amendment say? What are the actual words? The right of the people to keep and bear arms shall not be infringed. The so-called collective rights view that Professor Malcolm mentioned contends either that in the old view that states have a power to maintain militias, and in the more sophisticated collective rights view that individuals have a right to bear arms in a militia. Chief Justice Roberts asked the first question in the oral argument. This was in March, and he said, isn't it kind of odd that if the amendment means that the states can maintain militias, that it refers to the right of the people? You know, hello, right of the people, not militia, and the word right, not power. Governments have powers, people have rights. First Amendment talks about the right of the people peaceably to assemble. The Second Amendment, the right of the people to keep and bear arms. The Fourth Amendment, the right of the people against unreasonable search and seizure. And the 10th Amendment refers to powers of the federal government and of the states, powers not delegated to the feds or reserved to the states respectively, or to the people. The people can have powers also. But in every instance, the people are the only entity with rights. So it'd be strange if the founders meant to say the states have a power to maintain militias when they actually said that people have a right to keep and bear arms. And it's also strange to say that there's an individual right to bear arms in a militia when there is no right to even be in a militia or to do anything you want to when you're in that military unit, because they tell you what to do. Your commanding officers tell you what to do. And if you say, I want to bear a Smith & Wesson revolver, and they say you're going to peel potatoes, then you get court-martialed if you don't do what they say. So this is so superficial. One thing that's striking, it's always been striking to me about the collective rights view, is that those who make that argument are not exactly adherents of state powers. If you think about those who advocate gun bans and who say the Second Amendment doesn't mean anything, are very unlikely people to be saying that we've got to protect state powers over the militia against the federal government. One of my favorite things that was said in the oral argument was by Justice Stevens. There's no question he's going to vote for the collective rights view of the amendment. He said that he asked a question to counsel for Heller. Isn't it true that only two of the original states had provisions guaranteeing the right to bear arms that were individual in character? And all the rest were collective. Only two that way, all the rest were collective. Well, guess what? There were only two others that even mentioned the right to bear arms. And let's look at what they said. Pennsylvania and Vermont talked about the right to bear arms in defense of themselves and the state. Clearly individual, although there are those who argue that when they said themselves, that really meant some kind of collective body. It's like they meant to say the right to bear arms in defense of the state and the state. North Carolina adopted a provision recognizing the right of the people peaceably to assemble, and then the right of the people to bear arms in defense of the state. So even though there was the defense of the state objective, which was quite radical, by the way, I mean, we're talking about defense of the state against the constituted royal government, the right still remained in the people. And then the fourth state to mention this right added to keep and not just to have bear arms, and that was Massachusetts, which recognized the right of the people to keep and bear arms for the common defense. Even though that right for the common defense was mentioned, that did not mean that you couldn't keep arms for whatever purpose, because if you kept them even just for the common defense, you would still have a right to keep them. So it would not require authorization by government to do that. In fact, it was meant to make clear that the state government, because that was the only government in existence at that point that would have a power to interfere with the right, to take that right away. It was protection from the state on behalf of individuals. I was sitting in the oral argument with some friends in the counsel section, and everybody knows that to win a case, a controversial case in the Supreme Court, you've got to have Justice Kennedy's vote, right? So we're sitting there, and Kennedy starts to speak, and everybody's hanging on the edge of their seat, and he says, isn't it true, and he asked this of counsel for D.C., Walter Dellinger, isn't it true that the founders were, they were settlers, and they needed firearms to protect themselves from criminals, hostile Indians, and grizzly bears? And we all breathe a sigh of relief, like, Kennedy at least believes in the individual rights side of this equation, even though there were no grizzly bears in the East. He doesn't know that, but he repeated that comment 2 or 3 times, but we still liked it very much because it shows that he agreed with the individual rights interpretation of the Second Amendment. Justice Souter, and I'm not going to predict all of the justices how they're going to vote, but he will vote for the collective rights view. He quarreled with the issue of what is the meaning of bear arms. And he said, oh, nobody talked like that back then, to say to bear arms for hunting or to bear arms for self-defense. Bear arms meant purely a militia context. And that was argued in one of the amicus briefs, and there was a comment or a statement that we did some kind of word search in the old congressional record, and we found that a gazillion times when the term bear arms was used, it meant militia service. But the one thing that survey did not do is to look at when you have the word the right of the people to bear arms. Was that a militia context? And the answer is no. Whenever you see the term the right of the people referred to and then the term bear arms, it's always a context of individuals having a right to bear arms, as it literally states. And as far as people not talking like that, yeah, they did. The dissenting minority from Pennsylvania, as I mentioned earlier, referred to the right of the people to bear arms for self-defense, for defense of the Commonwealth, for hunting, and for national defense. Thomas Jefferson proposed, and James Madison introduced a bill in the Virginia legislature referring to bearing a gun in a hunting season context. So the term bear arms does get mentioned in the sense of simply meaning to carry a gun. Something that, by the way, Justice Ginsburg recognized in an opinion a few years back. So people did talk like that back then. The term bear arms simply means to carry arms. And when you interpose the term keep, and in fact Justice Souter asked, well, why do you need both keeping and bearing arms? It's like quarreling with James Madison. Why did you say both of those terms when you only need one? Well, it has both of them, and to keep arms means to possess them, to bear arms means to carry them. It's very simple. The next person I want to mention is Justice Scalia. He's always a treat if you've ever, they broadcast the oral argument. How many of you actually listened to it? Probably a good number of you. Justice Scalia tells a lot of jokes, and what I'm going to mention about his statement on this issue is not a joke or anything, but he made the point that the framers, as I mentioned, as we discussed in the book, in the pre-revolutionary period, they were concerned with the government taking individuals' guns away. How much was said about disarming militias? Very little. They were concerned with individuals being disarmed, and Justice Scalia also referred to the fact that in English history, Catholics were disarmed and Scots were disarmed, and that was very well known to the framers. And the actual fact was that when there was a Catholic monarch, they would disarm Protestants, as was complained about in the Declaration of Rights of 1789. And then when the Protestants took over, they would recognize the right to have arms for their own defense without mentioning the term the people. The English Declaration of Rights refers to the right of Protestants to be armed. So you have that kind of religious persecution. And by the way, when I litigated a challenge to the D.C. law that was going about the same time as this case that actually made it to the Supreme Court, and the adherents of collective rights views argued that firearm prohibitions are perfectly acceptable. You find them in American history. Maryland banned possession of guns at one point by Catholics. But they might as well have said, well, yeah, they banned possession of arms by African Americans as well. But in any case, the reference that Scalia made to the banning of arms possessed by Scots referred to what was called the Highlander Acts of the 1700s, where it was permissible and authorized by a British soldier to shoot on sight a Scotsman dressed in the traditional attire, because that traditional attire would include a sword, and those of you who have been to the Scottish festivals, you know, there's a dagger in the ankle, and that's the Scottish attire, and if you saw somebody like that, then you could shoot them for being armed. So those were comments made by Scalia in his book, A Manner of Interpretation. He explicitly endorses the individual rights view, so I think it's safe to say where his vote will be in this case. Justice Breyer is another story. Back about a year and a half ago, he debated Justice Scalia on how they interpret the Constitution, and Scalia said, I tried to figure out what the framers intended, and Breyer said, I tried to give reasons for my conclusion. And Breyer said, well, what about all this crime? Doesn't that justify banning guns? And so he didn't really have anything to say about the Second Amendment per se, but it was a policy argument. And Scalia said that, yeah, that proves why people in D.C. need guns. Justice Thomas, as usual, didn't say anything. But in Prince versus U.S., in his concurring opinion, he seemingly endorses individual rights view, and he endorsed George Malcolm's book, To Keep and Bear Arms, and my book, That Every Man Be Armed. So we were pleased with that. Justice Ginsburg is hard to predict on this issue because she said things that could go either way. But she did ask the D.C. Council, are you telling us that the Second Amendment doesn't mean anything today? And basically the answer was yes. The response was that unless the federal government violated some state power over militia right, the Second Amendment doesn't do anything anymore. And then we come to Justice Alito, the last of the nine, and the Second Amendment begins with a precatory clause, a well-regulated militia being necessary to the security of a free state. And it was D.C.'s argument that that completely swallows up the right to keep and bear arms. And Alito said that, well, wait a minute, the Constitution already had a militia clause dividing powers between the feds and the states. And what did this add to that? Nothing. So the militia clause of the Second Amendment is really a declaration of political principle that doesn't do anything to shift powers between the states and the federal government. But it was a declaration that when you take the entire amendment in context, by having the right of the people to keep and bear arms recognized, then you can certainly have a well-regulated militia, and that will contribute to the defense of a free state. And I'm glancing at my watch, and I think it's probably about that time. So thank you very much, and I'll turn it back over to David.